think $125,000 is a figure I can use. Let me see if I jotted down some notes here. $125,000. If you gave away $125,000, you would create a period of, under the old law, you would create a period of ineligibility on the first day of the month in which you made the transfer. Today, a $125,000 gift would create a 1.5-year ineligibility period. So, if you could give away $125,000 under the old law and keep it out of the nursing home for a year and a half, you would have been eligible. You would have been eligible for medical assistance long-term care because your period of ineligibility would have expired when you went into the nursing home. A lot of people used to use this thing called half-a-loaf gifting. What they would do is, the day they were going into the nursing home, so they had $250,000. They would give $125,000 to their kids, and they keep $125,000. Under the old law, your period of ineligibility would commence on the day you gave the money away. But you kept $125,000. And if you did your math correctly, the $125,000 that you kept, combined with your income, should pay for the cost of your care in a nursing home for a year and a half. And after a year and a half, your period of ineligibility would have expired. Deficit Reduction Act said, no more of this half-a-loaf gifting. Now, your period of ineligibility commences on the day you would become otherwise eligible financially for medical assistance long-term care. So if you had the case in which you had the $250,000 and you gave away $150,000 and you kept $150,000, after a year and a half, you've privately paid for a year and a half, you would come in and say, make me eligible. Under the new law, the state's going to say no, because it's the date you would be otherwise eligible. And it wasn't until you spent down the $125,000 you kept that you then became financially eligible. So now, your period of ineligibility will now commence, and you're ineligible for the next year and a half. So the period of ineligibility now commences on the date that you've completely spent down your money. And this kind of really rocked the elder law bar, because it eliminated a very easy way to move some of your assets around. Basically, what the federal government was telling individuals, you shouldn't have given the money away if you're going to a nursing home. You should have kept it, because you're going to need it to pay for the cost of your care. So you have to watch yourself when making gifts. You have to be extremely careful about it, because if you're not doing that, you can create a period of ineligibility. And a lot of nursing homes right now, when you come in, because they're going to ask you a lot of questions, one of them is, if you gave away money and you don't disclose it, you're going to get the door. And it's very difficult for nursing homes to have a person come in and then have to evict the person from the nursing home. But they're really faced with no other choice, because they're going to have no other method of getting paid. Now, the biggest asset that I think a lot of people have that they're concerned about is going to be the home. Okay, so if you have your home, you are able to be protected. Your home, if there's transfers between spouses are acceptable. In other words, when you come in, we look at, let me take one step back. This only has to do with individuals who have a spouse, okay? When a spouse comes in and has to go into a nursing home, what the state does is the state looks at all the resources that the couple has. It's what the couples have individually and what they hold jointly. And they're all added together. And when they're added together, the state then turns around and says, the community spouse, the spouse who's not receiving the long-term care, is entitled to a certain amount of those resources. And presently, as of January the 1st of this year, the maximum amount that the community spouse can keep is $104,400. That's the maximum amount. The minimum amount is $20,880. So if the couple came in and they only had $25,000, the community spouse gets to keep the minimum, $20,880. If they came in and they had $500,000, the community spouse can only keep up to the maximum amount. That's the $104,400. If you're somewhere between there, the community spouse gets to keep half of the resources. So if they had $150,000 of liquid resources, the community spouse can keep $75,000. The other $75,000 is going to make the institutionalized spouse, the spouse in the nursing home, ineligible because the institutionalized spouse is over the resource level. Those resources have to be spent down. And let's use, for example, I mentioned earlier, 2,400 hours. Once those non-protected resources, the institutionalized spouses share the resources, once they're spent down to 2,400 hours, medical assistance would kick in. You can spend them on, well, the state would like to see you spend it on your nursing home care. You can buy irrevocable burial accounts for both the spouses. You can put that heating system in the community spouse's house. If you've got $75,000 left in the mortgage, you can spend it on the mortgage. As long as you make a transfer for fair market value of those non-protected resources, once they're spent down, you'll become eligible for medical assistance long-term care. Now, you can also transfer the house over to the spouse. That's okay. So if you've got a house, it doesn't matter. If you've got a spouse, you can be over the $500,000 home equity. So if you've got a spouse worth $750,000, you can transfer it over to the community spouse. And that's what you should do. Because if you hold your house, as most married couples do, as tenants by the entireties, when one spouse dies, the other spouse gets the property. So if the community spouse, if you don't transfer your deed over to the community spouse, if the community spouse would happen to predecease the institutionalized spouse, then the house goes over to the institutionalized spouse. And if you've got a $750,000 house that's going to the institutionalized spouse, immediately that person's ineligible because they exceed the $500,000 equity. If the community spouse predeceases the institutionalized spouse gets the $400,000 house in, we'll say, his name. And when that person dies, there's a thing called the estate recovery program the state has, that we can recover for a real property. And even if it wasn't worth that amount, say it was only worth $400,000, against the probate estate of an individual who was over 55 years of age and receiving long-term care services in Pennsylvania. So if this individual had $300,000 worth of long-term care services and they ended up with a $400,000 house, when they went to probate that estate, the state would come in and take $300,000 of that estate. So you really have to know what you're doing if you're going to be getting involved in this area. Some things you have to move around. And another thing is this. I've had several of these cases that have come up that to me is almost, well, it's malpractice, I guess, that the individual comes in, the property is held as tenants by the entireties, they come in, the house is transferred over to the community spouse, they don't change the will. And if you look at most of your wills, when you have a husband and wife, the wills normally say, I leave everything to my wife if she survives me by 30 days. If she doesn't survive me by 30 days, I leave it to my kids. That's standard in will language. So here you made the transfer of the house going to the community spouse, and then when the community spouse dies, the community spouse's will leaves everything to the person in the nursing home. And it's going to be titled in the name of the nursing home individual. So there's a lot of nuances they have regarding this, but you can transfer the house over. You can also transfer the house to a disabled child. That's an exclusion. You can transfer flat out to a disabled child in the house. You can transfer it to a child under 21. So the house can be protected if you have a minor child, a disabled child, or a spouse. If you don't have those, they're probably going to get the house under the estate recovery program if you're a single individual. Unless you want to get married, late in life, that's the only way you can protect that. Now, one other thing. Once you transfer the house over to the spouse can't get rid of the house. You can sell it and buy another house. We give you 90 days to buy another house. But the reason why we gave you that exclusion was so the spouse would have a place to live. So if the spouse decides they want to give their house to their kids for $1, that will create a period of ineligibility for the institutionalized spouse. If the house is worth $400,000, it'd be for $400,000 worth of long-term care. And presently, the average cost of private pay in Pennsylvania for long-term care is $227.61 a day. So if you do, it's going to be a substantial amount of time the individual will be ineligible. Because remember, I said there's a look back that we talk about that goes back 5 years. Well, it goes back 5 years, but it goes on to infinity. It's any time after that look back date. It doesn't stop after 5 years, it continues. So if the community spouse has the house, and we've seen cases in which the community spouse says, I don't want to live in this house, it's too old, the kids are gone, it's drafty, and my husband's in a nursing home now, and he's in a different county. Well, the community spouse can sell that house and buy another house for approximately the same amount of money, maybe sell the house and keep the money, because if you sell the house, the community spouse can't keep the money, all that money then becomes available for the institutionalized spouse.